Hi, I'm Beth Walensky, legal practice professor at the University of Michigan Law School, and today we're going to talk about legal research. This video contains an introduction to the very first step of the legal research process. Now, to learn how to conduct legal research, you really need to learn 4 different things. First, how do you think about a legal problem? Then you need to learn the nitty-gritty information about how law is collected. Where do you begin your legal research? And then, how do you use those resources to efficiently conduct and create a research plan and follow through on the steps? This video is going to cover just that first step. How do you think about a legal problem? To do that, I'm going to talk you through how I would go about the thinking stage of a research problem. First, I want you to watch this short news clip, it's a little over 2 minutes, to learn about a hypothetical client. Now, imagine that Hunter's parents have come to me seeking legal advice. They want to know whether they can sue Hunter's school over its insistence that Hunter change his sign language name. In legal terms, they want to know whether they have a valid claim against the school, whether they are likely to win a lawsuit. So let's imagine that I talk with them in my office, and then I send them on their way and arrange to meet with them in a week. And in the meantime, I plan to research their legal issue to see if they have a viable legal claim. Now, the first thing you always want to do is sit and think. Even though your instinct is likely to be to turn on your computer, to open up Westlaw or Lexis or another legal research site and start typing stuff in and searching right away, the time you spend at the beginning of the process just thinking through your client's facts is going to be time well spent for the entire process. It's going to make your research much more efficient. So how do you think through a problem? I like to think of it as being like a journalist asking questions. You want to ask the who, what, when, why, where, and how of your client situation. So I'm going to talk you through what I mean by that using Hunter's case as an example. But first, one thing to keep in mind and to watch out for as I'm going through the who, what, when, why, where, and how is to remember that you usually want to look at a problem from both a very close-up, detailed-oriented perspective, but also to pull back and look at the big picture. And I'm going to show you, as I talk through Hunter's problem, places where I've thought about his facts in a very specific, detailed way, and then pulled back to think about it more broadly. Both of those perspectives could potentially be helpful when I'm conducting my research. So let's start with my who question. So it may seem obvious who the parties are here. They are Hunter Spanger and his parents on the one side, and the school on the other side. But I want to think about the relationship between the parties. So what I mean by that is here I have a student, and I have his parents, and I also have a school. I want to think broadly, though. There's more than just Hunter and his parents in the school. There's also the school district, which is a separate legal entity from the school. There's a principal. There are potentially teachers who are involved. The who might even include other students and parents in the classroom. For example, one of the things I might be interested in is whether other parents have complained about Hunter using his sign language name. So that's thinking broadly about the who. But I also want to think specifically within each of my who categories. So for example, I know that one of the parties I'm interested in is the fact that it's a school, but I want to be more specific than that. Is it a public school or a private school? Here it's a public school. It's a preschool as opposed to an elementary school or a middle school, high school, or even a college. Now, keep in mind that I don't know at this point whether any of those distinctions are going to have legal relevance, and that's okay. I'm just brainstorming all the different potentially relevant facts. Why that's helpful? That's helpful for 2 reasons. First, those kinds of things are likely to help me guide my research as I start and go through the research path. Second, those kinds of detailed ways of thinking about the facts are likely to help me recognize potentially relevant case law when I come across it, as opposed to discounting something that seems like it might not be relevant. Now we have the what. So again, the what might seem kind of obvious here. This is the what happened. Because the thing that happened is that Hunter and his parents were told that he needed to choose another sign language name. So that's a good start in thinking about the what. But one thing I want to make sure I do is think about the what from both perspectives, from my client's perspective, but also what the other side claims is its story. And we know from the video, for example, that the principal has suggested that his story, his view of what happened, is different from that of my client's. He says that he has never required a student to change his sign language name. So I want to make note of that. I'm also kind of intrigued by his use of the word required. It suggests to me that maybe he could have encouraged or asked or even pressured a student to change his sign language name. So as I'm conducting my research, I might want to be on the lookout for situations in which that distinction mattered or where it didn't matter. For example, where it's possible that courts have said that it doesn't even have to be a requirement. If a school is encouraging or pressuring a student to do something, that would be treated like being required to do something. So other ways to think about the what broadly. I've been thinking about this as a claim about a deaf student who wants an exception to the school's policy so that he can use his sign language name. It's very helpful, though, to pull back and think about how to categorize who he is and what he wants. And here's what I mean by that. He's not just a deaf student who wants an exception to the school's policy because of his disability. I could also think of him as a disabled student who generally wants an exception to the school's policy. Why is that helpful? It means that as I'm conducting research, I am more likely to recognize that other cases involving students with completely different kinds of disabilities could be very analogous to Hunter's claim. And it's going to help me spot and recognize the significance of those cases. Whereas if I'm just focused on a deaf student who wants to use his sign language name, I might miss the significance of some of those cases. Then I can also think about this more broadly as a question of disability law on the one hand, but also potentially a question about education law. So I want to make sure that in my notes, and by the way, as I'm thinking through all of these things, I am taking notes on all of these potentially significant ways to look at my client's situation. I want to make a note that I might want to approach this from both the disability angle and from the education angle, because again, at this point, I'm not sure which path is likely to be most fruitful. Finally, for what, I want to think about what my client wants. Does my client want money damages? Does my client want an injunction requiring the school to allow Hunter to use his chosen sign language name? Does my client want a broader injunction that would prohibit the school from ever telling a student in the future that he or she can't use a sign language name? I want to think about those things because I may need to conduct some research on which of those remedies, if any, are available. So now we have the when. So there are lots of cases where the when questions you might want to ask seem obvious. For example, where the timing of events is at the heart of the legal claim or defense. If you have a case involving a potential statute of limitations issue, the when is highly significant. So what do I mean by statute of limitations? That's a situation where there's a question about whether the party bringing the legal claim, the party filing the lawsuit, has waited too long to do so, because lawsuits have to be brought within a certain amount of time of the significant underlying events occurring. So in that circumstance, the when is an obvious question to ask. Similarly, you might have a contract claim where there's a dispute about whether one of the parties has fulfilled its obligations in the amount of time that the contract requires him to have fulfilled those obligations in. Again, there, the when questions will probably bubble to the surface pretty easily. But lots of cases have other potentially significant timing questions. It's helpful to think of them in a couple of different ways. First, you might think certainly just in terms of days that have passed. So in Hunter's circumstance, for example, I might be interested in when he started using this sign language name. In the video clip, one of his parents said that they've been using it to identify him since birth. That might be significant, as opposed to, for example, a situation where he had just recently started using that name. I'm also interested, for example, in when the school informed Hunter and his parents that he couldn't use the sign language name. Did they inform him immediately on the first day or when they first saw him use this name? Did a couple of weeks go by before they told him that? And if so, maybe those three or 4 weeks or more went by without incident, and all of a sudden they said, oh, by the way, he's got to change his name. Those are the kinds of when questions that I think about when I think about days. But sometimes the time of day that something happened might be relevant. Sometimes the amount of time it took something to occur from start to end might be relevant. So those are other potentially significant when questions. Now, let's talk about why. So here's the key thing to keep in mind. Every party has a why. That's the reasons it took the actions it did. Just as in the what sort of set of questions that I asked, I want to think about the what happened from both my client's perspective and the other side's perspective. When I'm thinking through the why, I want to think about why each party acted the way it did. Because again, this may help me identify potentially helpful and efficient legal research paths, and also identify potentially relevant case law when I come across it. So for Hunter, I want to know why it's important to him and his parents that he use the sign language name that they've chosen for him. And again, this might seem obvious, right? It's the name that he has used since birth. It's what he's most used to. It seems really unfair to say to him, you have to change your name, and not say that to other students. That does, though, suggest to me that there might be more than just a disability claim here. I wonder if there's potentially an equal protection claim, because Hunter has been told he has to change his name, and other students have not similarly been told that. But also thinking even more broadly about the why, I think about the expressive function that our names have, that people choose their names or parents choose names for their kids because they think that they like the way they sound aesthetically. They think it expresses something about their child. It can be a very personal decision. That gets me thinking that maybe there's even a potential First Amendment claim that I might want to pursue in my research. Now I want to think about the school's why. Why did the school take this action? Does the school have a written policy? Does it have an informal policy, a formal policy? In the video, there's mention of the zero tolerance weapons policy, so I want to know a little bit more about that. Is the school following some state or federal law which requires it to have a zero tolerance weapons policy in place? Those kinds of things might be highly significant to whether the school is allowed to take the actions that it did. So next we have my where questions. So here again, there are some obvious where questions. I want to know what state the events took place in. Here, that's Nebraska, so the where is pretty easy. That tells me that when I start conducting my research, I'm probably going to want to look at Nebraska law and also probably federal law, because it's likely that there is federal law that affects a disability claim like this one is potentially likely to be. And as I mentioned, I'm also interested in even possibly pursuing due process or First Amendment claims, at least at the research stage. So those would be federal claims as well. Sometimes the events took place across several different states, so I need to figure out what happened in which state, because that can be highly significant to which state's law might apply. And then there might be other where questions depending on the situation. Maybe it matters that, for example, here that it's a public school and not a private school, for example. In another case, I might be interested in the fact that the where is a military base or a doctor's office or a retail store. Those are other where questions that I might make note of when I'm thinking through my research plan. And finally, the how questions. These are usually due process questions, but they aren't necessarily. But here, for example, I'm interested in how the school implemented this restriction. Did it just tell Hunter's parents informally that he's not allowed to use this sign language name anymore? Did they send him a letter? Did they send him institute a formal process? Did Hunter's parents have any chance to appeal or present their own side or bring in someone to help them argue their case? These are all how questions that might be relevant as I conduct my research. So now that I've gone through this thinking process, I am probably about ready to start my research. There are a few other things that I want to make note of for you. First, to think through what question you've actually been asked. In the example that I've given you, I'm imagining a client coming to me with a big open-ended question and me kind of thinking through all of the different things I might want to pursue in my research on behalf of this client. It is often, however, the case that you are given a much more discrete question, whether it's because someone that you work with asks you to go research one small piece of it. For example, you could imagine that maybe you work at a law firm and someone has asked you on behalf of Hunter to research just the discrete question of whether he can obtain money damages if he wins a case like this, or if he's only entitled to injunctive relief, to an order that requires the school to let him use his sign language name. So if you've been asked to research just that question, it's still helpful to conduct a very abbreviated version of the who, what, when, why, where, how inquiry. But you don't want to allow yourself to get too distracted by some of those other questions. And the same is true, for example, in a law school class. If you have been given an assignment that asks you to focus on one thing and there are a lot of other things that come up, you want to use good judgment in thinking through what kinds of inquiries are likely to be helpful in answering the specific question that I've been given, and what kinds of inquiries are possibly interesting but not the best use of my time. Finally, you don't want to try to tackle all of these things at once. I've thrown a whole lot of stuff out here that I would research on behalf of Hunter. In the next video that you will see about legal research, you'll see some different ways to get started, but I might have to break it up and focus on just one piece at a time and start almost a new research process over when I want to tackle each specific part of the question. So for example, I might start out focusing on the narrower disability question. Can a school require a disabled student in these circumstances to change his sign language name? Or is a disabled student entitled to an exception to the school's policies? And under what circumstances might a disabled student be entitled to such an exception? And then once I feel like I've done a thorough job of researching that, maybe I'll go back and I'll investigate the First Amendment angle. Maybe I'll investigate the equal protection angle, and then take on some of the other questions. But that's the basics of how I would sit and think through a legal research question, again, before I turn on the computer, before I start typing anything into a search box, before I go to the library or even start reading a treatise. These are all the kinds of things that I want to have thought about.